Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net. Excuse me. And I want to welcome you to today's webinar on assessing the TCPA legal landscape post-Facebook. Now that the Supreme Court has issued its long-awaited ATDS ruling, it seems as though the floodgates may have been open. In the first month following the ruling, the number of TCPA lawsuits increased from the previous month. Today in this webinar, we have a panel of TCPA experts who are here to assess the current legal landscape and share perspectives about how the number of lawsuits will evolve in the months to come. Before introducing the panel, I want to take a quick second to give my usual spiel about the accountsrecovery.net Slack channel. I just put a link in the chat window to join. If you haven't joined yet, not sure what you're waiting for. Completely free, doesn't cost you anything. We're closing in on 600 members now. We're using it to stay connected with one another, interact with one another, share, and just sort of spend time together. So really encourage everybody to join if you haven't done so yet. There's a link in the chat window. All you gotta do is click on it and you're all set up. Now let me introduce you to today's panelists. David Kaminsky is the chair of the financial services law practice at Carlson and Messer in Los Angeles. He represents debt collectors, banks, other creditors, and asset buyers in the defense of all claims brought under federal and state consumer protection and related statutes. He manages the nationwide litigation for numerous financial institutions and has helped shape the law affecting the rights of creditors and the accounts receivable management industry. David provides compliance and training advice and develops policies and procedures for the arm industry. He was an ACA International Foundation Fellow Award recipient, the ACA Attorney of the Year, chair of the Attorneys Division of ACA International as well. Christine Riley heads Manat's consumer protection, advertising, and competition practice. She defends companies in class actions and other major civil litigation in various arenas, including consumer protection, unfair competition, and false and deceptive advertising. She also represents clients facing investigations and proceedings initiated by the FTC, FCC, and other federal and state regulatory agencies. While leading Manat's TCPA compliance and class action practice, she regularly defends companies from claims brought under the TCPA and other federal statutes. Nicole Strickler focuses her practice in the defense of consumer litigation, including the FDCPA, FCRA, TCPA, and Illinois Collection Agency Act. Her clients include corporations, lending institutions, collection agencies, asset purchasers, lawyers, as well as individuals. She's an active member of ACA International, the Consumer Financial Division of the American Bar Association, and holds a position on the board of directors of NARCA, the National Creditors Bar Association. Eric Troutman, a partner at Squire Patton Boggs, is one of the country's prominent class action defense lawyers and nationally recognized in TCPA litigation and compliance. He has served as lead defense counsel in more than 100 national TCPA class actions and has litigated nearly 1,000 individual TCPA cases in his role as National Strategic Litigation Counsel for major banks and finance companies. He also helps industry participants build TCPA compliant processes, policies, and systems, and is the mastermind behind TCPAworld.com. Our format for today is going to be a panel discussion. We encourage everybody to submit questions, and we'll get to them during the course of our conversation today. To submit a question, you can do so through the Q&A tab on your Zoom webinar control panel or enter it through the chat window. Since we're going to be talking about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area. It should never be used to replace the advice of your own legal counsel. Without even looking, I got that now. I got that down. Said that so many times. All right. Let me stop talking now. I'm going to bring in our panel because that's what everyone is here for and everyone wants to hear from. So there was a big increase in TCPA filings leading up to the Supreme Court's ruling in Do Good v. Facebook. In the months since that ruling's been issued, curious what you're seeing in terms of the trends and what we're seeing just overall in the number of TCPA cases. And Nicole, we'll start with you.
Sure. I would say in terms of filings, I've seen less. I know for a period of time, at least prior to the ruling, I saw it as a natural follow-on to a lot of the Fair Debt Collection Practices Act cases that I had, where it would kind of almost be like a throw-in at the end, all these parade of debt collection horribles. And by the way, the TCPA as well. I've seen less of that. I mean, there's definitely still filings taking place. There's definitely still cases that are out there. Um, but like I guess it remains to be seen really how it will truly affect the volume. I'm curious to see if others on the panel have seen something different.
Well, if I can jump in, Mike, and first of all, thanks for the intro. From now on, just call me a guy. No more bio. Just Eric Trotman. He's a guy. The end. Um, so look, we track every filing every day for TCPAworld.com, of course. And as Mike correctly pointed out, there was a big kind of push up at the beginning of the year. Following Facebook, actually, there was a tick up, which was interesting because it seemed as if there was kind of a volume of cases that were being held back, which hadn't been filed. And then after Facebook came down the way it came down, it was like the floodgates opened for a moment or two. Now, these cases, I should know, are by and large not ATDS cases. These are cases filed looking at pre-recorded voice calls and at DNC violations under 227C. So that is what you're seeing. The new push post Facebook is not ATDS cases. It's pre-recorded call cases and DNC cases, which were not impacted at all by Facebook. The same rules that applied before to those calls still remain today. And I will note, and I want to hear from others, of course, as well, that on the ATDS piece, the plaintiffs bar, when I talk to these folks, I know, Mike, you've got good relationships with these guys as well. They tell me we're not going to flood the courtroom with ATDS cases anymore. We're not going to do it after Facebook. That would be silly of us. We'd be wasting resources. Instead, what they're doing is they're picking and choosing their spots. They're picking what jurisdictions they want to try to test ATDS arguments like footnote 7 or capacity. They're choosing their defense counsel. No offense, if your ATDS cases haven't been dismissed, you might have been picked. And they're choosing the facts and the defense that they want, the defendant that they want to go after. So they're being very strategic. Dave, Christine, have you folks seen the same thing?
Yeah, generally, Eric, I agree. I'm seeing an uptick in the do not call cases under 227C of the TCPA because the do not call, as Eric mentioned, it's not ATDS dependent. And that is what you call the low picking fruit for the plaintiff's bar. That's the type of cases that they want to hit on because they think that they have moxie in the marketing area. And even attorneys that I think all of us have seen that were solely staying away from all of the marketing type cases, the do not call type cases. Now they're getting into that arena because that's where it's all about. It's all about also the pre-recorded message call cases. Pre-recorded message call cases, again, are completely independent from auto dialer cases. As you know, the TCPA says that it's illegal to make a call using an auto dialer or a pre-recorded message. So that pre-recorded message stays away from the ATDS definition. So that's the type of cases that I'm seeing as well. Yes, I think some text message too, because I think the plaintiff's bar believes that text message platforms inherently have some kind of random and sequential number generation capability. So they still think they have a fight on many text message platforms with respect to the auto dialer fight. But by and large, we're seeing more of the pre-recorded message and the do not call type cases, some of the ATDS marketing cases as well, but more so the focus on text, pre-recorded, and the do not call.
I'm seeing very similar things as the rest of the panel. I think it's a little too early really to come up with, assessed trends. It's only been a month and about 2 weeks since the decision. And as everyone knows, it takes a while to get cases through the court system to figure out where they're going to focus things, what the courts are going to do. So a lot remains to be seen on how the courts will deal with a lot of these new and creative arguments that are going to be made. But to the extent that I've seen cases, I've seen similar things. I still see a lot of filings. Maybe not the same kind of volume as previous periods, but I still see cases filed every single day because I get the same alerts that probably Eric does and the rest of the panel. So I still see these cases filed. I do know that plaintiff lawyers are not been shy about saying that they're going to focus on pre-recorded voice message cases because that's easy, low-hanging fruit for them. They don't need to worry about auto dialer. And it also triggers both residential landlines and mobile phones. So pre-recorded voice message cases are great for the plaintiff's bar. I am seeing more do not call cases as well. And I think, like David had mentioned, I'm also seeing a lot of cases on text message platforms. Those cases are auto dial cases. And I partly think that maybe we're seeing some of these filings because the plaintiff's bar wants to test out these theories that they have about how Facebook works with text message platforms. I think that's going to be a really interesting place to watch. What will happen with those cases? How will courts look at Facebook and interpret random and sequential number generation in the context of a text message platform? Those are going to be some interesting cases, and will probably take the latter most of this year, if not part of next year, to really get some good rulings and get a trend in place.
Eric, to your point about sort of, plaintiffs' lawyers kind of picking their spots, are they looking for some new area? Are they looking to sort of establish some court, find a hole somewhere where they can focus on? Is that why they're doing it, or is there just not a lot of different areas for them to be suing under right now?
No, the plaintiff's bar has always been way better than the defense bar when it comes to working together and being strategic, right? I mean, they've got NACA and
I think he froze.
I'm waiting for him to unfreeze. Maybe the plaintiff's bar got to him.
Maybe.
Oh no, go get them. Switch sides, Eric.
We thought the plaintiff's bar got you, Eric.
Eric, we lost you.
Oh, you lost me?
Yes.
Oh no, my internet connection is unstable.
Uh-oh.
Oh no, what happened? They're taking me
I
out.
hate
I'm
that,
telling you,
that warning.
it's the dark group. It's the dark group. They're coming.
They're
They're
taking
coming
me
for
out.
you.
They're taking me out. All right, can you hear me? Can you hear me again? Now let me try this again.
Yes.
Yeah.
All right, so these guys, they've always been way better than the defense bar when it comes to working together. They've got forums and they're very strategic, right? They share information way better than the defense bar has ever done. And they will look for the locations and the best facts, right? The one where their guy got hammered with 2,200 calls, and they'll find a jurisdiction in Massachusetts or Minnesota or California or in Washington, places that are traditionally viewed as more consumer friendly. And they'll pick, a good defendant, and they'll pick, and I say this with love, defense lawyers that don't know what they're doing, right? And they will put together a very compelling case, and they will try to argue one of a number of different possible arguments, right? Because after Facebook, we know that the system has to have, right, the ability to use a random or sequential number generator to either store or create numbers to be dialed. We know that. But what that means in the context of what equipment you're analyzing, what capacity exists that might be latent in the system is yet to be determined, right? It's going to be in the eye to a certain degree of courts and to a certain degree in the eye of experts. And so what you're going to see, what you're already seeing is, again, I believe it's largely going to be strategically determined, although, as I was saying before I got cut off, there are guys like Manny Geraldo, they're just going to do it their own way, right? They're not going to wait to listen to everybody else. They're just going to go off and they're just going to do it their way. But you're going to see very well developed expert reports. You're going to see very well developed and crafted and carefully crafted briefs that have 15 lawyers looking at them before they get filed. And they're going to try to tease out of footnote 7 or out of capacity in certain jurisdictions, again, on good facts, and hopefully from their perspective against defense lawyers that aren't as steeped in this stuff. And they're going to try to get little tiny wins here and there until over time they can hopefully take a body of law that they've created themselves, cobbled together, and expand it. So to Christine's great point, this is not going to happen overnight. I would expect to see ATDS cases, very rarely filed for the rest of the year. And most of the ATDS cases that were pending and stayed pending Facebook are being dismissed. All of mine are being dismissed, right? They're gone. I don't even have ATDS cases anymore. And actually the one thing that I've picked up on so far that was curious to me that I have not seen is a focus on text ATDS cases. I, of course, am on the record saying that triggered texts, AI texts, one-to-one texts are plainly covered by Facebook, are plainly no longer subject to the TCPA. Blast text technology, kind of a different animal, But the one-to-one texting, I mean, I'd be shocked if that is where the plaintiff's bar is focusing. It just seems like the most uphill battle. Anyway, hope that answers your question, Mike.
So Mike, if I could just dovetail with that, and this footnote 7 in the decision, plaintiffs' counsel now are using that footnote 7 as a semi-frisbee. What I mean is they're tossing it around and saying, okay, well, maybe your system doesn't have a random and sequential number generator, but then there's footnote 7 and that saves my case. Well, first of all, footnote 7 in the Facebook decision was where the court was talking about a random and sequential number generator having the capacity to store numbers and also to randomly sequentially generate them, and for the random and sequential number generator to store them and maybe call them at a later time. For some reason, the plaintiff's bar is picking up this notion that the random and sequential number generator is not needed. And as long as you have an auto dialer that can somehow randomly and sequentially generate numbers and then call them later, you have an auto dialer. But if you read that footnote 7, and what the plaintiff's bar, I think, is taking completely out of context, is the fact that it's very specific. What the court says in footnote 7 is that you need a random and sequential number generator to have either sequentially or randomly generated numbers, then either to store them to be called at a later time. They're trying to divorce the whole concept of random and sequential number generator from the entire decision, and saying as long as you have a predictive dialer that can sort of randomly sequentially generate numbers and dial them later, well, then you have a dialer. It's absolute nonsense. It absolutely makes no sense. No one in the plaintiff's bar really knows how to use that. They're just throwing it around to say, okay, instead of $5 million, now I'll settle your case for $150,000. But that's where you really need to push back, and you need to be thinking about these ridiculous arguments that the plaintiff's counsel are making to try to save any kind of auto dialer claims that they have, but they really don't have any teeth. That's just my view of it.
And maybe just for the benefit of everyone listening, I'm just going to read the sentence in footnote 7 that we're all talking about, so everyone is on the same page as to the language. It's really this one sentence that has the plaintiff's bar throwing around frisbees, as David says. And this is what the sentence says. For instance, an auto dialer might use a random number generator to determine the order in which to pick phone numbers from a pre-produced list. And then there's a site, it goes on, it would then dial those numbers to be dialed at a later time. And citing the PACE brief. Of course, if you've read the PACE brief, you understand that this is not an eloquent way of summarizing what PACE was trying to say. And this is really just a disservice to a great brief that they had put together. The whole point was there was an argument about whether it even made sense to store numbers using a random or sequential number generator. The plaintiff's bar jumped up and down and said, well, that doesn't even make sense. So that's why you should read the statute in a different way. And what PACE said is, no, it does make sense, because there were these generators that had the ability to generate random numbers and then store them for a little while and didn't necessarily dial them. And it explained a patented technology that did it. So I think the language that really causes the heartache here is the pre-produced list. As it sounds like the plaintiff's bar is going to be arguing that since there's a pre-produced list, they're going to try to make the same kind of arguments they were making before, such as, this may sound familiar, dialing from a list of phone numbers is still an auto dialer. That pre-produced list language that I just read is really where some of the heartache is. And I think it's a complete misread of what was intended by the Supreme Court. Unfortunately, it was not well drafted and not well thought out, but I think it's going to ultimately come down to these courts. And I think you will see some courts may bite on it. Some courts, may look at this and say that they either don't like the Facebook decision or they don't understand it. I mean, random and sequential number generation, it's not easily understood. All of us can talk about it for an hour and you might still be confused about it. Think about the courts that don't specialize in this area and work in it every single day. So that's really where the concern is, to have some of these judges who don't really understand it and that are very liberal take that particular footnote and just expand what was intended in Facebook. It's going to take some time to figure it out. And most importantly, we're really going to want to know, what do the federal appellate courts say? I mean, the district courts are fine. We want to know what they have to say, but ultimately, what we really want to know is, what does the federal appellate court say? And specifically, what does the courts like the Ninth Circuit say? And the Ninth Circuit, as everyone knows, is California and surrounding states, is a very large jurisdiction, very pro-consumer, very pro-plaintiff, generally speaking. So all of this are going to have to be, I guess we're just going to have to sit down and wait to see how it all shakes out.
A couple of quick notes just following up on what you just said, Christine. First, on footnote 7, what I'm telling my clients is, look, if your system has the capacity to randomly generate numbers, any numbers, not phone numbers, any number, for any reason, the plaintiffs are going to use footnote 7 to hook you. Okay, so make sure your system does not have that ability. It's very simple. And just be very careful when you're talking to a platform provider, because I see this all the time. The platform will say, we don't have the ability to randomly or sequentially generate telephone numbers. And we'll say, oh, okay, well, that's all we need. No, that is not what you need. That is not what you need. Telephone numbers is not the issue. Footnote 7 makes it broader. The use of a a random or sequential number generator for any purpose, not just to generate phone numbers, for any purpose, footnote 7, the plaintiff's bar is arguing, opens the door to that system being an ATDS. To David and Christine's point, that's dumb, but that's the argument. Okay, so you got to keep that in mind. And then one other thing to keep in mind, Mike, before we throw it back to you and probably talk about human intervention, I think, Christine raises the appellate review. Remember, Laboom, Duran versus Laboom Disco is on remand to the Second Circuit right now. That's a text message platform case. Allen is on remand right now to the Sixth Circuit. That's a predictive dialer case. Okay, those cases are in front of the appellate court today. We could have a ruling from either of those courts in the next 3 to 6 months, in theory. So, I mean, this could really develop very rapidly at the appellate court level. So keep an eye on it.
I'm curious to ask my own question to our panel. So the random or sequential number generation component, and I understand footnotes 7 and, for any purpose, but maybe it'd be helpful for those out there to know, what are some of the other purposes in which their systems could be generating using that random or sequential number generation that they should be asking about specifically? Because I think that's really something that until now, really nobody was really focused on the other purposes. We were always looking at, well, to store or to produce. We weren't really looking at for the other purposes. So what are you all seeing in terms of other purposes, in particular equipment, that people should be focused on?
No plaintiffs are listening to this, right? So look, virtually any operating system is going to have that capacity, as does SQL databases, as do Excel spreadsheets, right? The Excel platform. The reason that the operating systems do it, as I understand it, I'm not like a super techno guy, but I dabble, is that there's syncing components between your clock, the internal clock, and, for instance, your email that's going to have a date and timestamp, and all of this is done, as I understand it, due to like quantum fluctuation, using random and sequential number generation to help sync everything. I don't know how it all works. I'm not going to pretend to know. But this stuff is going to be latent in many operating systems. Now, does that mean that if you've got an auto dialer sitting, a dialer sitting on an operating system that has this capacity, that your system is an ATDS? No, of course not. It's ridiculous. But that risk is there. But what you're talking about, what we really need to be focused on, is the software platform itself, the dialer, the soft phone, the predictive dialer, whatever it is. Does that system, that software, have this latent capacity in it? And it really shouldn't, but I'll tell you, I've done source code reviews for systems that, they say it's not going to have this, capability. And then we start digging in and we start going through the code, and I'm like, let's line of code right here. What does that do? Oh, well, that allows you to generate numbers. Okay, why? Oh, because blah, 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 blah. Okay, how does it generate numbers? Oh, well, it's syncing. How's it syncing? Well, it's kind of random. And all of a sudden you just go, oh my God, right? So I encourage you to really dig in, get into that source code, get the programmers on there and just kind of just ask them like, what does this do? What does this do? What does this do? You don't have to be a genius in like coding to just say, what does this do? And then follow it down the train to find out if you've got this capacity sitting there. But what I would encourage everybody is don't rely, whatever you do, don't rely on a sentence from a platform that says, we do not have the ability to randomly or sequentially generate telephone numbers to be dialed. It's just not enough post Facebook.
I agree with that. What a concept that I've talked about before is legacy software. A lot of companies don't realize that some of their dialing systems have something called legacy software where there is random and sequential number generation capability built in and hidden within that. They may not be, quote, using it at the moment, but it's there, and this legacy software can be unearthed and it sits and resides within the system. So if you have, let's say, legacy software with random and sequential number generation capability that you are unaware of, that is why you need to go deep with your IT professionals, your experts, and you need confirmation about the system that you're using and why it does not have random and sequential number generation capability, and to be asking your IT professionals, your experts, et cetera, what about legacy software? Do we have any legacy software? Because if you do, then that gives the plaintiff's bar folly to say, okay, you didn't necessarily use this legacy software, but at least your system has the, quote, capacity to randomly and sequentially generate, and capacity is the word that is still used in the statute, is the capacity to dial using a random and sequential number generator, either for a storage purpose or to produce numbers. So that's something I think that needs to be, taken into consideration in a very serious manner.
Can I give you guys a use case? Because I have this going on in one of my cases right now. And I just see that there's a comment from the audience that gets to my use case. So this is the argument being raised in one of our cases. The plaintiff's bar, and this is even before Facebook, but now that Facebook has come out, they're arguing it even more. They're arguing that because our client has a database, that when it saves accounts, it sequentially numbers the accounts. So let's say you're taking data from, I don't know, various sources, you're putting that into your CRM, into your database, and then you assign that account some type of number, 001, 002, 003, so on and so forth. They are arguing that because our client has a database that sequentially numbers these accounts that has phone numbers, there is a random or sequential number generator, and therefore the way that text messages were sent or auto-dialed. So I leave this to our esteemed panel to discuss this very real use case, which I think is probably one of the most dangerous arguments that can be made, because a database can do a lot of different things. A database is not telephony. A database doesn't dial phone numbers, but they are, as Eric said, are going to attach random and sequential number generation to any place they can in the universe that could be your system, whether it be the actual dialing system or the database that connects to the dialing system, the whole universe. So I'm interested to hear what the panel has to say about my use case, because I'm dealing with this right now. Give me all of my good arguments, my good briefs.
Christine, all I have to say is, obviously we'll all as experts sign affidavits attesting to the fact that we do not believe that constitutes equipment within the purview of the TCPA. I think really that's all you need,
I forgot to add one important thing. Our case is on appeal in front of the Ninth Circuit.
Oh, the Ninth Circuit.
So I don't think our case is going to be the case in the Ninth Circuit that gets into the auto dialer issue, but so is possible. So we're just briefed it. But I just wanted to add that because it is a Ninth Circuit case, and our argument will probably be scheduled for end of the year or early next year.
Yeah, and so I love it. Obviously, it's very creative and dumb, as most of these arguments are.
I like the dumb part.
Yeah, I mean, facially, we know it doesn't work because of the statutory language references, in fact, the use of a random or sequential number generator to store or produce, wait for it, telephone numbers to be dialed. Okay,
Right.
That's what the statute says. Now, I understand
Exactly.
footnote 7 departs from that, but that's what the statute says. So the use of a system that generates numbers for other purposes, such as account numbers, assignment, shouldn't matter. But as we already said, it might, right? And that is exactly the sort of case that, to your point, Christine, I think it is dangerous. Now, luckily, there's other case law out there, which I love, frankly, which looks at Excel and its capability to generate random numbers, looks at SQL, looks at its capacity to generate random numbers, which is very akin to a database or CRM that's generating numbers in this way, and says it's not an integral piece of the dialing function, right? And so it's kind of a different way of looking at it. It departs from the statutory analysis and looks at the functional definition of what the equipment is that's subject to the analysis, and says this stuff over here isn't part of it. Only the software itself is. So I would imagine you're probably already raising both of those arguments. You've got some good case law to tread on both of those arguments, but I'm glad you highlighted that use case, because that is exactly the sort of thing we're talking about, right? That's what footnote 7, ridiculous though it is, opens up.
And Eric, you know, to that point, there was a decision, I'm forgetting the one that said that your dialing system may somehow tangentially be connected with your Linux computer. And just because the Linux computer has the potential or the capacity to randomly and sequentially generate numbers in it, that would mean that every single system in the United States that dials, that is somehow connected to some kind of computer equipment that somehow has a Linux interface, is now an auto dialer. And they said that's ridiculous because that is not part and parcel of the system. And I think that is the focus. And so that it's almost like the ridiculous argument when plaintiffs were saying, you know, look, if we have a if the statute, or what we were saying on the defense side, if the statute exists as it was, and if the FCC had its way, then even every single cell phone in the United States that had capacity to quote auto dial numbers would be considered an auto dialer. And that's why, you know, the statute at one part in the FCC's definitions and the interpretation went too far. This is another instance where the argument goes too far, because I like when the court pointed out that every system in the United States would be deemed an auto dialer using random and sequential number generation, and that's just not the way that particular system works. So you got to be very careful how you make your arguments. You got to be able to make sure that you're parsing those arguments properly, and that you're not letting these ridiculous arguments carry the day, because plaintiffs are going to push them as far as they can, because they're dying and grappling to save the auto dialer cases that they have, and they're going to be looking to every single argument to push the agenda. That's what they have to do.
And the case that David just mentioned is Panzarella versus Solutions. That's an Eastern District, Pennsylvania case, June 16, 2020. Go ahead, Christine.
Thank you.
I was actually going to say, I think that was always a very persuasive argument that I was disappointed that the FCC overlooked initially when they came out with their rulemaking in 2015, was the comparison you could make to the modern cell phone. Because if you do really carry that definition, or the one that they were, you know, asking for, every modern cell phone is an auto dialer. And I thought it was great that, you know, both in ACA International and now with the Supreme Court's decision, there seems to be some recognition of the effects of an order that would expand, or even, you know, future rulemaking that could expand potential liability for the average consumer making calls. And I think originally the FCC's explanation for that was just something like, well, we don't really see any of those cases or complaints, so we're not going to worry about that interpretation, which is really like the worst way to make decisions in the entire world, in my opinion. But I digress. But I think it'll be interesting to see whether the court, particularly the Ninth Circuit, because, you know, eventually they're going to look at it, whether they take a different approach to those type of practical arguments than in the past.
You know, it's interesting. I think after the Ninth Circuit got slapped so badly in the Marks case, I think they're going to be looking at the auto dialer issue in a far different way. And believe it or not, as we have seen from the Ninth Circuit, and this may be due to many of the Trump appointees between 2017 and 2020, the Ninth Circuit has taken on some issues a little more of a conservative approach. I had a case not too long ago that dealt with a standing issue, and people laughed at me and said, "Are you kidding me? The Ninth Circuit is going to find that there's absolutely standing in the case." And quite the contrary, the Ninth Circuit, with a 3 Democrat panel, pushed back on the issue of standing in a very visceral way and pushed back on the plaintiff's theory and found no standing in a particular case, and really went out on a limb and really was sort of following the 11th Circuit Trishelle sort of theory on standing. So I think we're seeing a little more of a conservative trend. Like, look at Nicole's 7th Circuit. My God, look at how they have taken a conservative trend over the last 3 to 4 years. I've seen decisions out of that federal circuit like I never expected. So look, things are changing. People are taking a little more common sense, a little more balanced approach than we have seen in the past as far as a statutory interpretation. So we hope that trend continues with respect to any federal circuit court of appeal that may look at the auto dialer issues here.
Somebody raised pre-recorded voices and the scope of the statute, Mike, and I just want to address that real quick. The counter trend to what David was just describing is that the courts are taking a very broad view on what constitutes a pre-recorded call. In fact, initiating a call, even with a pre-recorded message like "this call may be recorded for customer compliance or quality assurance," that is sufficient in the eyes of some courts to constitute the use of a pre-recorded call, both requiring express written consent if it's for marketing purposes, and secondarily, maybe even more importantly, triggering the 227D content requirements, and also under the 47 CFR 64-1200. So that's really serious stuff, and definitely something to keep in mind. If you are using, for instance, a predictive dialer and there's a wait queue message, you just recognize that that could be viewed as the use of a pre-recorded voice call. And of course, those of you that are familiar with the marketing requirements that if you don't connect a call within 2 seconds, you have to then give a pre-recorded announcement, you know that you are necessarily then triggering, right, the express written consent rules, even though technically you wouldn't have needed express written consent. For instance, if you're marketing using a system that's not an ATDS under Facebook to an existing customer, you wouldn't have needed PEWC. But if you are then going to a wait queue, you're going to need it. One last note on that, of course, the FCC has held now that avatar, right, soundboard technology is the use of a pre-recorded voice call. There's still one really important petition pending to the commission, which was brought by Assurance, looking at, again, the snippets, right? These, if this call may be recorded for quality assurance, that kind of thing. The commission is being asked in the context of 227D to confirm that that is not a pre-recorded call. But that has not been ruled on yet. So it's still sitting out there. It's an open issue. So there's a big, hornet's nest around what is or isn't a pre-recorded call right now. So it's something to keep in mind. And unfortunately, it's not going well in the courts. So, and obviously ringless voicemail, definitely a pre-recorded call. I feel safer with auto dialer and less safe with pre-recorded call. Yeah, that's exactly right, Andy. That's how you should feel.
What about the issue that's being raised? And I think it's a good one. So it's sort of like pre-recorded voice messages on steroids, because now the argument is, at least the plaintiff's bar is going to argue that text messages are actually pre-recorded messages or pre-recorded voice messages. Now, or if you are like me and you are constantly wedded to your phone and sending voicemails, you may use the voice dictation feature on your phone, which I use all the time to dictate messages and respond to emails. And it does, or you can actually send a snippet of your voice if you wanted to, and you can send a text message that way, or you could just send a text message and write it out. But either way, the plaintiff's bar plans to argue that those are pre-recorded messages. I would like to think that those arguments will be shot down pretty quickly, because that's not what's intended by a pre-recorded voice message. We go back to the history of the TCPA when pre-recorded voices were an instance where you were sitting down having dinner with your family and the phone would ring and you'd get this automated voice and you weren't able to get rid of it. You couldn't slam the phone down on someone, a live person. You couldn't get out of the pre-record. Sometimes it would tie up your line. Clearly not what was intended, but I think we have to all be prepared for that creative argument and see where it goes. I don't see how it's a pre-recorded voice message, but I do worry about some of those courts. Like Eric, you mentioned, well, what if you get defense counsel that maybe is not as steeped in this stuff, or you get a judge that is just, wow, it's a creative argument. Sounds good to me. Could be another dangerous argument that may come into play in the next several months.
I'm just going to stick a pin on that, Eric. Sorry, one quick second. I'm a little late in getting the sponsor promotion out there. So I want to take a quick second and just talk about TCN, a global provider of comprehensive cloud-based call center platforms for enterprises, contact centers, BPOs, and collection agencies. Today, they announced the launch of TCN Operator, the next generation of its flagship program. Platform built for the modern call center. TCN Operator features an intuitive interface and comprehensive set of easy-to-use automated agent tools and advanced apps that all work together to boost agent productivity and improve customer experience. TCN Operator's features includes omnichannel communications via voice, email, and SMS text that provide a seamless, unified experience for call center agents to interact with customers on whichever channel the customer prefers. Business intelligence, reporting, and analytics that provide a 360-degree view of call center operations to identify anomalies or trends and generate actionable insights for evaluating current operations and optimizing future operations. Data management and compliance tools that ensure adherence to the TCPA, FDCPA, and other state and federal regulations, including new and updated debt collection rules issued by the CFPB. Workforce engagement and seamless integration and automation with third-party services and applications. Grounded in TCN's deep understanding of call center needs, TCN Operator is built on the company's vast experience in supporting billions of interactions every year between call center agents and customers. For more information, you can click on the link that I just put in the chat window to learn more about TCN Operator. And a special thanks again to TCN for sponsoring today's webinar. Eric, I'll put it back to you.
Well, first of all, that was a big brag, man. TCN claiming they've got the hack for TCPA compliance. Man, that's worth looking at. Maybe, I don't know. But okay, so man, I was listening in so intently, Mike, I forgot where we were. We were talking about pre-recorded voice calls or something. I mean, what do we got? What was the question?
I think we were talking about text messages being a pre-recorded voice. Look, I think if you go back to the history of the TCPA and you look back as far as 1991 and all of the orders subsequent thereto, they were always envisioning a pre-recorded message to be a voice message. Even though the text message is deemed to be a call for the purposes of the TCPA, no court that I am aware of has ever deemed that a text message constitutes a pre-recorded voice call. And I think the word the voice is the key here. It's a pre-recorded message. It must be, quote, an aural, A-U-R-A-L sound, and it's not a bunch of words. So I understand where the plaintiffs bar is trying to go with that. Even some of the plaintiffs counsel I've talked about, and they know about this theory. They do think it's ridiculous and that it's not going anywhere. And I think it will be quickly shot down by the courts, even by some of our more liberal brethren throughout the United States in various courts. I just don't think it has a path.
Yeah, I will say that frankly, it's no more ridiculous than saying that a text is a call to begin with. Right? I mean, if a text is a call, why wouldn't it be a pre-recorded call as opposed to a voice call? Right? I mean, what are the differences between the two? I don't know. My point is this whole concept that a text message is a call is dumb, but we have to live with it. So when you take the next level of dumb on top of an original level of dumb, who's to say they're not going to get there, right? Like, it's just one abstraction after another. Obviously, the use of the word voice should mean something. To me, I think the bigger hurdle for the plaintiffs' bars they've just come too late with this argument. There's too much body of law out there that says that it's not a pre-recorded voice. If they had brought this argument back in 2008, 2009, 2010, frankly, they probably would have pulled it off. Again, because why not? Like once you crack the door that a text is a call, why wouldn't it be a pre-recorded call? It's just some other sort of call, right? But it's too late. The case law has already developed that this is not a pre-recorded voice call. It is treated as a regular ATDS call, if you will. There's literally hundreds of cases on point. So, I mean, just sorry, guys, you're too late to the party. That's the dead argument, in my view. Christine, you want to tee up the big one that we need to talk about?
Okay, folks, the attendees are banging down our doors and they want to talk about human intervention. So let's discuss human intervention. It's always about the footnotes, right? Everything that's juicy tends to go in the footnotes, not in the body, but in the footnotes. So Eric, I know you have some firmly held beliefs on human intervention. So why don't you start us out?
Well, I was just going to say, this is the place where Christine and I are absolutely going to disagree with each other. And this is good for all of you that are listening, because this is where it gets fun and exciting, because so much we're like, I agree, the panel is correct, we agree. This is where we just disagree, okay? Just disagree. So I have always hated human intervention. I hate it. I'm a black and white guy, right? Give me the definition, give me the functionalities, tell me what the bar is, and I will hit it, and I'll make sure that my clients are protected. You give me something like human intervention that means nothing, and just any judge can decide, yeah, it's enough human intervention for me. Nah, it's not quite enough. There's no standards. It's just gobbledygook. And like my mind starts melting because I hate it. I just hate making an argument to a standard that doesn't exist, right? And it's just, the judge just is fully empowered to just decide what is and isn't ad hoc at that moment based on the record before him or her. I hate that. I just hate that. So I love footnote 6 of Facebook, which does away, in my opinion, does away with the whole human intervention framework. It's gone, it's dead, it no longer factors in. What factors in now is the capacity of the system, black and white. Either it has the capacity or it doesn't. And yes, there are some gray, as we talked about earlier. 1, what does capacity mean? And 2, what's the contours of the equipment that's under review? All right, so it's not as perfectly black and white as I would like it to be. But the use of a random or sequential number generator to store or produce phone numbers, cool. That is black and white. And I will take that trade 100 times out of 100. So my view on human intervention right now is that, strictly speaking, human intervention is irrelevant. Now, it matters from a practical perspective, however, because, for instance, a click-to-dial system, right? Critically important, not on the issue of human intervention, critically important on the issue of functionality. If the system cannot operate except when a human being is clicking a button, guess what? The system is lacking the ability to store or produce phone numbers using a random or sequential number generator. Rather, the system is utilizing a human being in a one-to-one basis to launch that call. The dialing, the storage, the creation of phone numbers, none of that is taking place in that context using this random or sequential number generator. And this human being clicking then becomes the critical functionality departure, if you will, between the difference between what is an ATDS and is not an ATDS. So I like it. I like that human intervention is dead because I always hated that standard. And I like that click to dial still matters and that human intervention as a practical effect on the analysis still matters, but it matters in a different way that is much more easy, in my opinion, to apply. So big fan. Christine, I know you disagree.
I do. So I am not a fan of footnote 6. And this is the perspective that I look in. I don't like things that are necessarily black and white. I like a little gray in my life, particularly where we can argue both sides of it and maybe there is uncertainty, but I'm okay with that. I'm okay living in the gray. First of all, let's step back for a moment. Footnote 6 says that human intervention really isn't the test. It's dicta. It's not a question that was before the court, but the court felt the need to address it since there was probably, a lot of discussion about human intervention. So arguably it's not binding on any court. It's in there. We know what the Supreme Court thinks. I'm not sure it's dead yet. I think that's really up to the courts to figure out if they think human intervention is still relevant. I think you'll probably find, no surprise, as some courts will say it is relevant, and some courts will say it's not relevant. It's going to just depend on the circuit and how they view this. But a lot of the circuits can just say, listen, it's dicta and I don't need I don't need to apply what the Supreme Court said.
So
Now, putting that aside for a moment, what the courts do, this is the reason why I don't like footnote 6. First of all, human intervention has been a staple of how autodialer has been defined, going back to early 2000s, at least from the FCC. The basic function of an autodialer is to make calls, automatically and without human intervention. We all know that without human intervention is not in the statute. It's not. It's not a phrase in there, but it is so firmly held in the FCC opinions for a couple of decades now. It's firmly entrenched there. So that's one thing I don't like. I also don't like the fact that so many of you have been working so hard over the years to get some human intervention in your systems. You have been designing platforms and calling systems to insert human intervention in order to shore up your systems in a way to try to prevent an auto dialer assessment or conclusion as to your dialing system. There's a large body, a long history of spending time and money developing some level of human intervention. It'd be a shame for us to just throw it away and say it's not relevant anymore. So that's the second thing. And we have a long history there. And many of you are saying, well, gee, we already implemented human intervention. What do you mean it's not relevant anymore? I designed my system. I made changes. I made them do 10 digits. I made them do at least a click. I made them do 3 clicks, even though you said 1 click was maybe enough. Whatever the case may be, we have been designing compliance around human intervention. So it's another reason that I don't like it. And I guess third, I like being able to argue it. And even though, if you can make enough arguments on where there is some human interaction, it can get you over the line in these cases of being an auto dialer and not. It might even help you at the pleading stage. So I'd rather take another arrow in my quiver and use it to the extent I can rather than lose it altogether. So that's my opinion, but I'm interested to hear what David and Nicole have to say on this footnote 6.
I'm sort of a bullish guy and a defense guy, so I align sort of more with Eric. Look, I think the human intervention and what companies have done over the years to, follow what the FCC said is that you have sufficient human intervention. We won't tell you what it is, but if you have sufficient human intervention, then we'll deem that your auto dialer does not constitute an auto dialer because it requires a human intervention to intervene and therefore cuts off the fact that is, quote, automatic. As the FCC said years ago, look, there was no bright line rule for themselves. They said, we don't know how much automation is going to be necessary. We leave that up for the courts to decide. And that did create a mess. But I do applaud all of these companies that came out with these systems that implemented so much, human intervention. They said, look, how is this possibly an auto dialer under any construction that you can imagine of this rule? And on top of that, our system does not contain random and sequential number generation. There's no way it could be added to our system. So while I do think that the human intervention issue is frankly dead, and I think that footnote 6 gives that support, and I think that the Supreme Court wasn't going to hear anything about human intervention, I wouldn't be surprised if the plaintiff's bar still try to pushes some issue with surrounding human intervention, and therefore it is another tool to make one more defense argument that supports the case that you don't have a dialer. But I like the fact that these systems that have, let's say, designed themselves around human intervention, the click to dials, et cetera, the one-to-ones, what they've also done, these systems are saying that we don't have random and sequential number generator, and you cannot add that to our system. And if you added it to our system, it literally would shut the entire system down. That's the beauty of all these systems that have been designed this way. And we see the comments, hey, is it time to get rid of our systems that use this click to dial or this, human intervention to make the system work? Not necessarily. I think you have to look at what do you do, what type of dialing you do, what type of, what are the type of things that you do within your company, what are your policies, procedures, and protocols, and is this the right thing for you? And does it help you to make that argument, look, this thing is so far-fetched and so far astray from any kind of random and sequential number generator system that I'm just sticking with what I got. And I think it's sometimes that may be a safe road to take. It certainly is a risk-adverse position.
I was just giggling at Nicole responding to these comments.
Nicole, you're up. You're up.
I mean, I really think the focus is on the random or sequential number generator to store or produce calls now. Now, may human intervention affect that? Maybe, but the question again goes back to whether that affects the random or sequential generation. I think that's a conclusion that I read from both the entire opinion and footnote 6. I think the court doesn't want to draw lines about how much human intervention matters. They don't want to engage in that analysis because, again, they're strict constructionalists, and so they're not looking at that anymore. Now, obviously, if the FCC comes out with a rule and, you know, some interpretive rule relative to that, and that may change the analysis, but right now, I really don't think it matters so much. So if some of you have questions out there, well, you know, do we really need this click to dial anymore? Or this, you know, particular system that's more expensive than a different system? I think you should totally be looking at that. Because I know historically, like the clicker agents and whatnot are more expensive than other equipment that's out there. And I think this is totally a time to reassess your system and say, can I do something different that's maybe cheaper or more effective for me? Because I'm not so much worried about the human intervention anymore. It doesn't matter. It matters whether there's the random or sequential aspect and how that, you know, how that integrates into the system. Now, what I will say is what I'm most interested in is the other aspects of the system that can have the random or sequential generation that may not necessarily be obvious. I definitely think that people are going to get way more into the code and the other aspects that are out there, because this is such a moneymaker for plaintiffs' counsel. Like, I call this statute a company killer. Like, this is like a company killer because, you know, it's strict liability. It's either $500 or $1,500 and it's per call. So it adds up so quickly. It's a class action attorney's dream. That's why, you know, you see so much of the litigation out there. And I don't think they're going to give up. I think they're just going to try to find new and more creative ways. But just to circle back to the whole human intervention thing, I'm kind of leaning into the camp of I don't think human intervention mattered the way it once did.
For compliance purposes, I think we're all saying the same thing. You know, I think everyone should think that human intervention may not be an argument you can make, may be entirely foreclosed. And I think for compliance purposes, you have to assume that you can't just rely on human intervention. I think every single person on this panel can agree that if your argument is that you're going into court and your only argument is, I have a lot of human intervention, that is a very dangerous place to be in light of Facebook. I think you're going to have to focus for compliance purposes on the other elements of capacity and random and sequential number generation. And that's where you're going to have the focus. Now, if you do have human intervention, if I had a case, I'd still argue it. I would still argue it's relevant. I'd still argue that you have it. I'd argue it as another argument, but that can't be my only argument. I want to be able to argue everything. I'd want to argue you don't have the capacity, you don't have random and sequential number generation. And if you have an argument that there is human intervention, I'd make it too. I'd make every argument I can to shore up the assessment that it's not an auto dialer. But for compliance, you cannot assume that just because your system has a lot of human intervention, you're safe. You have to focus now on random and sequential number generation and capacity, even more so than before, especially the random and sequential number part, because for a while that was just read out of many of the jurisdictions. The jurisdiction said it didn't matter, but now the Supreme Court says it does. So we're changing the focus of the discussion.
And Mike, I'll just note as we get to the top of the hour here that there's still a lot in the FCC's court. We haven't talked about the FCC much, but that public notice proceeding from post ACA is still out there. And the one big issue, and I say this kind of with a smile on my face, is that capacity is still out there. And ironically enough, The ACA decision set aside the 2015 omnibus less on the expansive definition of capacity that the FCC adopted and more on the inconsistent functionalities that the commission was looking at from 2015 versus earlier orders. Now that the Supreme Court has clarified functionality, technically the FCC could come right back with the same order on capacity. So it's just something that's still dangling out there. Nothing would foreclose the commission from coming back with the exact same ruling from 2015 if it chose to. And I hope it doesn't, but I haven't seen many comments out there in the record. So
Or
more to
Congress.
come.
That too. I imagine those plaintiffs' bar lobbyists are working to modify it in a way that'd be more beneficial to them. People have always said the statute's outdated.
Yeah, we're working on that too. And let me just say, there will be a TCPA 2.0 eventually, and it will not focus on technology. Focusing on the technology used by scammers and robocallers is dumb. Content is what matters. Just because a legitimate business is using the same system as a bad guy doesn't make the legitimate business a bad guy. That's ridiculous. If the call is a lie, if it's a scam, you can bar content consistent with the First Amendment where the content is not constitutionally protected. Lies, scams, sedition, things that pose a clear and present danger, none of that is constitutionally protected. And TCPA 2.0 absolutely has to take the First Amendment into account because, of course, the last TCPA, at least as broadly interpreted by Marx and the FCC, turned the TCPA into the single broadest restriction on constitutionally protected speech in our nation's history. And it was unconstitutional from the start. It should never have been permitted. The courts didn't take the right First Amendment approach in analyzing it. But in 2.0, I think Congress is going to, and I'm going to do my level best, and Squire Patton Boggs is helping industry with the lobbying effort. It has to take the First Amendment into account. It was, in my opinion, it was an abomination what happened the first go around, and I'm not going to let that happen again. I'm going to do my best to make sure it doesn't.
And just to dovetail on that last point, Eric, there was California tried to implement its AB 3007 last year, which was an amendment to its public utilities code, which literally redefined the automatic dialing and announcing device law to mirror the Marx Ninth Circuit decision. But in light of all the constitutional issues and challenges, and in light of course, the Facebook decision, AB 3007 right now is dead and is not coming back in its same force because it will face significant constitutional challenges and could be dead on arrival if they try.
Excellent. Well, unfortunately, we've run out of time. I know I could listen to the four of you keep going on for forever, and even on a topic as the TCPA, that just sort of speaks to your expertise on the subject. So Eric and Christine, Nicole and David, thank you so much for your time and your wisdom. On behalf of everybody who watched and learned and listened today, thank you very much. Really appreciate it. I want to thank TCN one last time for sponsoring the webinar. If you haven't checked them out already, go to tcn.com. There's a link in the chat, and it should also pop up on your screen when I end the webinar to share your feedback and suggest any other topics you want to see addressed in an upcoming webinar. Starting to plan June's now, so if there's something you want to see, now's the time to reach out and make your suggestion. We're back tomorrow. We talked about the TCPA today. Tomorrow we're talking about the FDCPA litigation trends. If you haven't signed up for that, there's a link on the events calendar of accountsrecovery.net. So hope to see you back then. Until then, everybody, thank you very much. Really appreciate it. Enjoy the rest of your day. Thank you.
Thank you. Thank you, panelists.
Everyone.
Bye, everyone.